The state wants the right to appeal Oscar Pistorius' acquittal on a charge of murder. But to do that, it needs to show that in reaching her decision, Judge Thokozile Masipa misapplied the law. It cannot challenge her findings on the evidence, meaning the findings she made supporting Pistorius' account of the shooting cannot be overturned. The state has argued that Masipa misinterpreted the legal principle of dolus eventualis, or murder committed with indirect intent. She should have found, the prosecution argues, that Oscar Pistorius must have foreseen and reconciled himself to the fact that firing 4 shots through a closed door could kill the person behind that door. That finding, the state says, would make Pistorius guilty of murder. Not so, says the defense. Advocate Barry Rue says Judge Thokozile Masipa made a factual finding in the circumstances of this case, on the evidence before her, that Pistorius had intended to shoot the person he believed was an intruder behind his toilet door. She found that he hadn't intended to kill that person. Pistorius' lawyers say the judge correctly found that the state failed to prove on the facts of the case that he subjectively foresaw the possibility of death ensuing from his actions. They further dispute that Masipa's judgment could create a far-reaching precedent. Pistorius' lawyers also argue that the state failed to make a case that the Paralympic athlete's 5-year sentence was shockingly inappropriate. They point out in court papers that there is no dispute over the fact that Reeva Steenkamp's parents said they were satisfied with the prison term. The state's leave to appeal application will be heard on December 9th in the North Gauteng High Court. Karen Morn, Pretoria.